Yes, welcome to the No State Project live from the fortified compound in Mesa, Arizona for the last show of 2019. The worst year of my life is drawing to a close. So hopefully 2020 is going to be better. People should start filing in here soon. Glad to be with you. And appreciate the support of the show. If you like to support the show, it is very much needed and appreciated. You can do so at markstevens.net, my website, or markstevens.sells.com. That's SELZ. Sells. markstevens.sells.com. And hey, if you're being attacked by a bureaucrat, you want to learn how to more effectively defend yourself. Remember, there is no silver bullet. Anyone saying they can win every time, they're probably lying to you. But we have the government indicted and scripts and templates and full support to help you get through the process of being able to go to court and stand up for yourself and effectively defend yourself. And no one is supposed to take my word for anything. You just have to go and see the evidence for yourself at markstevens.net//success stories or just success. Well, the link is there on the website. And you can see documented proof of success. So we're all going to have critics, and so there are people that say I've never had any success whatsoever. You got to look at the evidence. It's not about me and my claims. My claims are nothing if they're not backed up. And so, unlike when critics say I've never had any success whatsoever in court, the evidence does speak for itself. And that's really what it comes down to. The evidence speaks for itself. And the evidence usually does speak for itself. Did I? I think I got disconnected from my call line. Oh, no, well, we're there. That was odd. We'll get to the callers here in a little bit. The number here is 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign. You can also get me on Skype at Frank Rizzo 3. Please instant message me first. And maybe I was thinking, you guys, should I just create, so instead of using Skype, well, I hardly use it anymore, now as far as chat, but maybe I will get more traction with Discord. So what do you guys think? I just start a server, called it No Stay Project. You guys, you let me know what you think over there. Yeah, Rika's saying, yeah, I should do the Discord thing. Or maybe we'll do that after the show. Maybe it's where we can start doing role-playing sessions again in this upcoming year. I want to just address an issue quickly before I get to calls regarding judges. Some people are, because legally, technically, there is a remedy to suing a judge for what they do as a judge. Thinking that just because there is a legal remedy, that it would be a wise thing to go in and try to sue a judge, someone like Dick Noble or so many of these, Patricia Starr, so many of these judges who so blatantly violate any principle of fairness, just bending over backwards for prosecutors. And so Stephen had called the show before and talking about how the prosecutor didn't show up to court and got on his phone and called them and excused it. Prosecutor's office, unless you're in a really small town, they generally have other prosecutors that, just take the file and go. It's not a murder. It's just traffic. It's not a big thing. They do it all the time and, covering for each other. But we know that if you and I were to just blow off court, they don't pick up the phone and see, hey, how's it? Hey, how's it going? You were supposed to have court now. Can we convene this at a time that's convenient? No, they issue a warrant for your arrest. If they're going to make a call, it's going to be to the sheriff to have you arrested immediately. But no, no, unequal treatment. So legally, you do have remedy to sue a judge for damages if and only if, under this limited circumstance, and I don't have the citations off here, but maybe I'll cover that in another show. It was just something that came up right before the show, so I didn't have time to look it up. But I have discussed this on the show many times. So if the judge from the beginning acted without jurisdiction, then they don't have absolute immunity. But if they started with jurisdiction and then exceeded their jurisdiction, absolute immunity. That's kind of startling to me. And that's why I talked about on the show how judges at the Supreme Court saying, well, no, it's not like we're foreclosing on any remedy against judges because they're not criminally immune. Oh, it's not like you have an independent grand jury that you could indict judges. It's not like judges get indicted all the time. Although there was one impeached about 10 years ago. And the Senate did actually have a trial, and I believe they had witnesses, and he was removed from office. I forget his name off the top of my head. I do know that Adam Schiff was the House manager who actually prosecuted that, and they kicked a judge out of office. I think it was for kickbacks, stuff like that. So even if you do have hardcore, concrete evidence that the judge acted completely without jurisdiction, that's only a paper remedy. The real world, a judge it just doesn't happen. And they know that even if you could get to the Supreme Court and the Supreme Court upheld their own ruling saying, well, the judge clearly didn't have jurisdiction, you can't extend him immunity, it would take years and thousands of dollars in appeal fees to get, and you're not going to get to the Supreme Court anyway. The little people like us, we don't get to the Supreme Court. It's a numbers game anyway. So if your name is Bush or Gore, you get right in. You get right in. But the little people like us, those most of us listening to the show, no. So it's a total waste of time, which is why I talk about going and filing a claim for damages against the insurance company and naming the judge as a witness. Now, that would still be a fight that I'm sure that they would take, as far as necessary to deplete you of funds. But but as far as I know, judges don't have immunity from legal process. I mean, they're not immune from appearing as witnesses in court. But look who's going to make the determination on the motion to quash the subpoena. So if you're able to get the judge to testify as a witness, and you're able to get his own testimony and bring out that there wasn't a shred of evidence to show that their constitution, which is what is the basis of all their jurisdiction, no evidence that applies, then when you've got your transcript, then you can file to have them joined as an indispensable party because you've got evidence from his own mouth. Just like we get these prosecutors and we get these agents admitting that it was an assumption. Or I don't have to prove that. We have their own testimony that we can use then in a motion to join them as a party. I don't know anyone who's actually gotten it through. I think it would be extremely difficult, but I don't think it's as nearly as difficult or impossible is trying to sue the judge directly. So it's not that we don't have any remedy against them. It's just that it takes some work. I'd love to be able to maybe crowdsource something to help somebody out who wanted to sue the judge do it this way, where you go after the city or the county's insurance. And then once it gets into court, because they turn down, once you get into court and you can get, and if you're able to get past the initial motion to dismiss and get a responsive answer and it gets pushed into discovery, then you start firing off your subpoenas. You call the prosecutor as a witness, into a deposition. You call the judge into a deposition. We'll see. I'd like to be able to do that, but it takes somebody interested in going and doing that. And it would take some support from us because I don't have a pot to piss in, but it would take some support from the audience to be able to help pay for filing fees and stuff like that. But that would be something to get a judge in and a prosecutor into a deposition and start using their own words against them. Well, you can say, well, on such a day when I challenged jurisdiction that the prosecution didn't have evidence, you didn't allow that, correct? Right. And what were your grounds? Oh, because jurisdiction was a trial issue. Did you mean it was a trial issue only and couldn't be challenged at pretrial? It couldn't be challenged at arraignment? Okay. Start asking good questions. And I don't want to get into the ugliness. I've already, if it comes up, it comes up. I'm not going to bring it up. I've already spent more than enough time on the issue for this entire year. But if it comes up organically, it comes up. But my stand is, if somebody's making a claim, I don't give a damn however you want to paint that claim. If somebody's claiming XYZ against me or against you, fairness dictates we get the challenge act. Even due process dictates due process is notice and opportunity to be heard at a meaningful hearing. And if somebody's making a claim against you, they have to prove it beyond a reasonable doubt. And this idea, that's as far as they can go. No, as far as you go is proving it beyond a reasonable doubt, however far that has to be. That is what dictates how far they go, until it is proven beyond a reasonable doubt with a competent witness and competent facts and evidence. And okay, that is as far as they need to go. Not a line that's arbitrarily drawn. Prove it beyond a reasonable doubt. If you think your laws apply and I violated them, prove it beyond a reasonable doubt. None of this, I can't go any further. If you can't go any further and you haven't proven it beyond a reasonable doubt, that's what I'm talking about here. Prove it. Hold them to their burden of proof, damn it. They don't like that. They don't like that. Can't put, wow. I think we, all right. Well, we got a full boat of calls. So, and let me give out the number again. If you disagree with something I say on the show, give us a call. 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign or the hashtag. And you can instant message me and get on the show on Skype at Frank Rizzo 3. And I'll probably do a server on Discord, call it No Stay Project. And then, so when we have that available, then I will start doing that. Maybe we'll have that for the Wednesday show. We'll see. We'll see how things go over here. So what we're going to do, we're going to get to Mac in British Columbia. Let's see. Mac, welcome back to the show.
Hey, Mark. Yeah, can you hear me?
I can hear you good.
Hey, good to get on here. I love listening to your show. I'm just going to give you a couple of quick updates, and then I have a question. So with my parking ticket, they had, found me guilty and said I got to pay the maximum amount. I just I wrote a letter saying, where is the ruling on my motion to dismiss that there's jurisdiction on this? This is a violation of due process that this wasn't ruled on. And then I wrote no contract on the ticket and mailed it back to them with that letter. Then I got an email from the city that said, can you send us the motion to dismiss again? So I don't know, I guess they'd lost it somewhere along the way. So I sent that to them at the end of November, and I haven't heard back from them yet in regards to that. I don't know if I owe that money or what's happening with that.
Well, they think you owe it.
I don't know if that's a good sign or what's gonna become of that. What are your thoughts on that?
Well, did you actually have a hearing on this?
Yeah, I had an adjudication a few months back, and basically I just got a letter back. I gave the motion to dismiss at that hearing, the adjudicator just kind of put it to the side. He said, I'll read it at lunch. Then he got me to talk a little bit about like me parking there, which I shouldn't have engaged in. And then a few days later, I got the notice or the decision that, oh, you were parked when the meter was expired, so you owe us the maximum penalty. And if you don't pay it by November 26th, then it goes from $105 to $140. So that's when I had the 2 weeks to respond and pay that. And then by November 26th, I wrote that letter saying, hey, what's going on? You haven't ruled on my motion to dismiss wasn't ruled on, jurisdiction wasn't proven. So, this is a violation of due process. That's where that's at. So I guess I'm waiting to hear back from them on that.
Well, I think if they found you guilty, then that's in effect a de facto, denying of the motion. I wouldn't get too hung up on that. That's an issue prior to a judgment.
Yeah, exactly. That's what I said. I go, you can't make a decision whether I violated the bylaw if you haven't proven that the bylaw applies to you.
Well, I get that.
So I'm hoping they're sitting back in their back rooms discussing it. Sorry, go ahead.
Well, I get that. And I doubt that they're actually discussing it. I would say that except in extreme circumstances, these people don't even remember your name once you walk out of there. I think it's the rare instance, which I don't think any of us really want, when they remember your name. You start, you're in there a lot, or you really frustrate them to a point where they do remember your name. It's not my experience that names they just don't care about us. You and I are not important to these people whatsoever. It doesn't mean anything. It's just, you're just a cog in a machine to fill up their bank account and their pension fund. That's it. If we don't matter, yeah. I mean, someone has to really matter to you, especially when you're dealing with so many people, to be able to, remember the name. I would be looking more at I would be looking more at an appeal and of this to get it reheard, to say a motion for reconsideration, and also file a notice of appeal, rather than trying to get the motion heard, which I don't think is going to happen.
Well, you think I should leave it with them, or should I follow up and see where they're at? I mean, I don't want to, right now, it's kind of like they asked for the motion to dismiss. So I'm kind of sitting back and hopefully it goes away. I don't know. Or do you think I should follow up with them and being like, hey, what's the status here?
I would look to have the decision reconsidered. I had to throw out the decision and reconsider it based on the facts or the lack of facts that they had to prove to prove their claim. And I would file an appeal. Maybe you can get a regular due process type hearing, and not have such a summary type proceeding like you typically get with these things. So that's how I would do it. I don't think they're going to rule on the motion after you've got a judgment. I would go to reconsider, and I'd file a notice of appeal.
Okay. Perfect. So, and then that's the update on that. My Idaho speeding ticket, I made the motion. Got so many motions in with them. They haven't ruled on any of the motions, motion limiting, motion to dismiss, discovery requests, all of that. But they did offer me a continuance. I sent them a motion for continuance or telephonic hearing, and I just got a notice back or a call. I told them to call me because it was so close to the hearing. And then the clerk called me and said, the judge granted your motion for continuance. It's in February now, February 21st. So I'll see what it's... Can I push them on that matter and keep filing motions that, hey, can you rule on my motion to dismiss, or can you compel the prosecution to send me my disclosure, my discovery?
Well, I don't. One, there's no mechanism to get the judge to rule faster. There's nothing you and I or anybody can do. A judge is going to take whatever time, regardless of what the rules say. The judge can take whatever time you want. There's nothing. So that's really nothing we could, I don't like the idea of compelling the prosecutor to do anything. I think that either the prosecutor commits to be consistent with due process and fairness, and they provide the the discoverable material. They provide the Brady material. Let's say, for example, they say in plain English, yes or no, that the witness has personal knowledge of the matters they're testifying to, namely that the laws apply and you violated them, or they're not, and they're supposed to give you that. And I would rather that if they're going to not be fair, to file a motion to dismiss for prosecutorial misconduct. I'm supposed to be getting this material. I need this to adequately defend myself. They're responsible to do this. They're not doing it. So that's how I would prefer to do it. I think either way. Sorry?
I was going to say, I did file a motion for sanctions and prosecutorial misconduct because they had that ex parte communication. They originally moved my hearing date without letting me know.
Right.
So I did file that motion, and I didn't for sanctions, and I haven't heard back on any ruling on that one.
You could always put in for a telephonic hearing on that motion for prosecutorial misconduct. Did you also have in there that they're arguing without evidence?
No, I left it off that one.
Okay, well, we're pretty, it seems pretty obvious from what you told me that the prosecution is not going to give you the information. He or she is not going to disclose that. So you may want to follow up, with an amendment to your motion to, dismiss for prosecutorial misconduct and include that and ask to have it done telephonically.
Okay. Yeah, I will do that. Okay, so getting to my question today, can I do this challenge jurisdiction on, like, let's say a Consumer Protection Act? I'll give you the background. I got a business. We have like contracts. It's health, like fitness based, and somebody signs a 6-month contract that we get them to sign, and they can't cancel, but they have the Consumer Protection Act or whatever that if somebody moves out of the area, they can cancel and get a refund, or if a doctor says they're unfit to participate, they can get cancel and get a refund. So, I got this thing where they cancel their contract. I go, well, hold on, you're only a month and a half in. It says in the contract, any money owed, we're going to charge. So I charged them for the full 6 months, and I guess they went to the Consumer Protection Act, and now I got a thing saying you have to refund them $400. And I said, okay, cool. There's timeline issues, which I'm challenging, but I'm saying that's fine, but can you provide the factual evidence that the rules here, that this statute applies to me? And the guy's not having any part of that. So I just wanted to get your opinion on that, because now he's said, listen, if you don't pay her back by January 7th, I'm going to put this to my boss or whoever, the director, and you're going to get levies and other fines that are associated with the act.
Yeah, the same thing applies, because they're all doing the same thing. They're operating under the Constitution. Whether some want to admit that or they are. If you ask him, he'll tell you. He'll tell you straight out that that's where he gets his jurisdiction. I mean, it's just no different than the IRS. Is that the IRS can actually, what they do is they point to a specific amendment. So right here, 16th Amendment. To me, it's still the same thing. We're always going to be looking at what is the foundation of their claim of jurisdiction and then attacking that, okay, challenging that. And it's always the Constitution. Let me ask you this, regarding what happened with the customer, taking the codes completely out of this and looking at it just man to man.
Yeah.
Is it fair for you to keep, is it fair for you to charge them that? And so we're going to strip everything out, and we're just going to look at basic principles of right and wrong. If you were the customer, is that what you would want?
Well, here's the thing. If they were seriously injured or, so they're using the statute because she came in and said she doesn't have time anymore. She doesn't want to participate any longer. That was her initial reason for coming in Labor Day weekend. And we're like, well, no, you signed a contract. So she mentioned nothing of a doctor's note, doctor ordered her. So people do this. They're dishonest. So I get your point. If somebody really is not able to participate, yes, give them back their money. That's the moral thing to do. They're not able to participate. But this is after the fact where she's being dishonest and wants to get out of the contract. I guess did some research and then 2 weeks later went to the doctor and provided a doctor's note. So I get what you're saying. Strip everything out. I should give back the money if they're not able to physically participate. But I believe she's being dishonest with her reasons and went to the doctor after the fact to use the statute to break a contract.
All right, I got you. Okay, so if we strip everything out, you're still acting ethically. Okay, well, then I see no problem. I personally, I would take the agent to task on this because, and it's not. You see, this is something that I think is lost in the arguments. Purposely, you've got the agency jurisdiction as well as the administrative agency that hears the dispute or a court that actually hears it. So there's two jurisdictions, and both of them are based on the same damn thing. It's the Constitution. You were talking the feds, right?
The provincial. It's a provincial act.
Oregon. It's still based on the foundational, Canadian law. So, I would challenge it the same way. I just ask the questions, get what his actual foundational claim is, get them to admit to that, which they'll always do that. And that's your starting point. Once you're on the same page, now you can ask the questions, basically leading questions to bring out why he believes that that's true. And so that you can either bring out contradictions or get them to admit it's an assumption.
Well, he copied and pasted the statute. So I think, he hasn't said it, but I think his argument is that it says within the statute that the statute applies. Like, you know what I mean?
Sure.
That here in the statute, it says somebody can cancel if the doctor gave him a note. Like, I'm just summarizing here. So he copied and pasted that. Well, he's not seeing what I'm asking is, hold on. I think the next phone call or email I send him is going to be that, so a set of rules cannot state within it that those set of rules apply. You know what I mean? There has to be something else that says these set of rules apply. Whatever is in these rules applies to me and has jurisdiction over me. But I think he's caught up in the fact that it's just right here in the rules that the rules apply.
And one or two would argue that that's all they need to do. We've heard it many, 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 many times. Okay. I guess it's coming up organically. We got to talk about it again. I know from speaking to them, and that's why I say you talk to them, because we want to deal with the actual agent. So you're dealing with an actual agent. You want to deal with what his claim is, not what someone on the internet thinks, or me or anyone else. It doesn't matter what I think. It doesn't matter what a critic thinks. It doesn't matter. What matters is what this particular agent is accusing you of. And if you ask him, he'll tell you. So you're basing your jurisdiction, your foundational claim against me, that's based on that you believe that just because I'm physically in Canada, that your laws apply, your constitutional laws apply. He'll say yes. And that's your starting point. Now, again, just because someone on the internet thinks that that's wrong, we're dealing with the actual claims that they're making. And so that's why I say call them. That's why on my instructions, we always want to call and get that confirmation, whether we get in writing or we get them to admit it on the phone or we get them to admit it right in person. But it's very important to get that admission out so that you have a starting point to start to really effectively challenge them and bring out, like so many times you've heard me get, that's an assumption. That's how, that's why I would do it that way. Get them to first admit that that's the foundational claim.
I will attempt that in my next email or phone call. I'll probably phone him just because it seems that things are being lost in the email. He's just going to keep coming back. What if he just says, okay, forget it. I'm not dealing with you. I'm going to send it up and you're going to have fines or penalties levied against you for not complying with my decision. So I guess that becomes a decision that I would have to make at that point if I want to pursue it, or is it better for me to challenge it at the next level?
I would still try. And if they're going to do something like that, what I say is, look, sir, with all due respect, I'm trying to resolve this in good faith. If you have evidence of jurisdiction that you're acting in good faith and consistent with due process, then I we can move closer to a resolution. But
yeah, I said that in the email. I said, okay, this is what I owe her. This is the date I got the doctor's note, so I actually owe her this much back, and I'm ready and willing to pay it. I don't want this to escalate anymore. Can you just please provide me with evidence that the statute applies to me, that there's jurisdiction over me? So, and he just ignored all of that and was like, no, you owe her this much and pay by this date, and copy and paste in the statute. It says,
yeah, well, because what we're doing is we're saying that, we're, so in case it does escalate, we're able to show that even though we're willing to resolve the matter in good faith, they aren't. So I'm sure it's the same in Canada, that court is supposed to be a drastic last resort, that the clean hands doctrine is, look, you have to have clean hands before you come in here. You have to have done everything reasonably expected of you to resolve the matter in good faith, and you just can't. You're trying, but so on. So you're able to show that they're escalating it without exercising the necessary good faith to be able to bring it to the next level.
Perfect. That's what I thought. I just wanted to confirm with you before I started pursuing this and, continue on the challenge. That's awesome.
Well, BCC so much, me. Mark. Yeah, BCC me on the emails. I'd like to see them.
Oh, okay. Mark Stevens. What is it?
Mark Stevens at mail.com.
Okay, perfect. I will do that.
All right, excellent.
Thank you. I'll listen to the rest of your show. Thanks, Mark.
Appreciate the call. Mac in BC. I think I cut a little bit off of Mac there, but apologize for that. But we will hear from him again. And, this is just something that I'm accused of lying. I don't know if I really want to. Somebody did post about Baker versus Carr, and it lays out the political question doctrine and why I'm being accused of having never addressed this particular issue. My gosh, I don't get it. But let's get to some callers, some other callers first. And we've got time in the broadcast there. I always have a little more time on Saturdays than on the Wednesday broadcast. And unlike last week, last Wednesday, I will be live this coming Wednesday. So if you're not able to make it, don't sweat it. We'll get you on Wednesday. We've got Lady Tech from Avondale. Welcome back to the show.
Hey, what's going on, Mark?
Just wrapping up one of the worst years of my life, but I'm glad to. I'm glad it's coming to an end here. We'll be starting 2020. On Tuesday?
Yeah. Here we go again. No, it'll be good next year. I actually have a couple of things to say. The first thing that I wanted to say is, since Avondale, I've had another issue come up that has to do with judges that we might be able to work something out with. I might be the guinea pig.
Was that an Italian slur you just used against me?
Yes, it is. Yeah, I was born and raised in Philly, so I know that slang a little.
Guinea pig. And I think it's supposedly the basis of that is that you could hire an Italian mason worker for a guinea a day. The old coin of the realm. But I don't know. I don't know. I'm not Italian anyway, so why would I take offense at that? All right. So what's going on?
Okay, so what's been going on is I know I do things a little different than most people, but I built on what you taught me. I have had a situation. It was a traffic stop with one of these jurisdictions over here, and what happened is I ended up going after their risk management. The situation was pretty much like the judge screaming at them to tell them not to bring any more tickets from me into his jurisdiction. So they already wrote the ticket, so they pushed it to the justice courts. And I've been dealing with a unruly judge out there. On the same traffic case, it was abated initially when everything happened. So it should have been gotten rid of. The judge is still moving forward, but the city sent me a risk management consultant to basically try to figure out a number to settle on. It's been about 2 years and I haven't heard anything back from them, but they do know that it's a true claim. So I wanted to see why risk management accepted their wrongdoing and the judge is still moving forward on the case.
Well, I don't know all the details. Just because risk management might be accepting the claim doesn't mean that the judge is convinced that there are, that there's not merit to their complaint. And we'd have to go through the details to know. So walk me through this. You're telling you actually witnessed a judge yelling or screaming, I think was the word you used, at cops.
Listen, Mark, this same judge has literally, and I'll tell you, he's in Goodyear. Okay, this same judge forced the prosecution to do a settlement conference with me before trial. When I came into the settlement conference, he kicked the attorney out, like the attorney never came. He got rid of the case, and as I agreed for him to get rid of the case, the attorney pops his head in the door. The judge looks at him and says, well, I didn't think you'd want to be here for this. And he said, okay, and closed the door, and he was gone. So in the particular jurisdiction that the traffic stop happened, they weren't supposed to bring any more tickets for me in there.
But you said the judge was screaming at cops.
Okay, this is what happened. During the traffic stop, they had me pulled over. They were trying to get me to get out of the car. They brought in another jurisdiction, a cop from Avondale, a lieutenant from Avondale who had dealt with me before to try to get me out of the car. I contracted my whole way out of the car. They took the car. But the stipulation for me was, they were like, what do you want, for you to get out this car? I said, bring the judge down here to the traffic stop. They were like, oh, the judge isn't going to come down here. I said, call him. Right? So they took a minute. They called the judge. The judge was screaming at him on the phone. They weren't supposed to stop me anymore. Well, so he sent the prosecution down to my car to contract me out of the car. The contract was, if they take my car for the 30-day insurance hold that they supposedly had on the car, they're going to have to pay me $2 million a day.
What?
That was the agreement. I got out. Yes.
Okay, hold on.
That was the agreement.
All right.
I got out
the rails
car
now.
Okay.
All right. $2 million a day. Okay. So.
Yeah, it's already in the record for $140 million with the administrative fees.
Okay.
I need your help, Mark.
I got to tell you, I could help with risk management, but this whole contract thing, this has got nothing to do with a contract. And even if you've got paperwork into their office, that doesn't mean it's a matter of record that they're recognizing this. $2 million a day to hold a car. I mean, even if you have a legitimate claim against them that they're holding your car or even holding you, $2 million a day.
They told me it was a legitimate claim.
Who said?
The risk management. When risk management met with me, we met at a restaurant. One in the restaurant, they didn't give him a copy of the claim, so I had a copy for him. When he sat down at the table, he said, I don't have a copy of the claim. Can you give me some information? So I slid it across the table. When he saw the seal on the record, he said, this is a valid claim. And I said, yes. So they already know that they owe it to me. And they haven't stopped me since. Well, they stopped me one time since, and they sent it to another jurisdiction because the judge wouldn't take the ticket.
Well, all right. There's a lot to unpack here.
We need to catch up, Mark. We do. We need to catch. I took what you taught me, and I put the things that I learned here recently together, and they mesh very well.
But asking $2 million a day after holding your car doesn't mesh. Again, even if there's a legitimate claim here, right, and you can prove it, and $2 million a day is just, no one's going to take you serious on that. So you actually met with risk management at a restaurant. You didn't meet them at the office.
No.
And what did they give you now? So it's been 2 years. Since you say that they
Mhm.
said that it's a valid claim, but they haven't paid out on it.
No, they refuse to. They refuse to talk to me.
Well, it sounds like
They
they
won't. They
are.
won't allow me off of the hold line.
Well, it sounds like they are not agreeing it's a valid claim because they're not paying it out. I would get in touch with
Yeah,
them and
but
say,
he said it. He said it to me, and then they stopped all communication afterwards. This is why I need a little more support in trying to get this claim. Even if we can settle for less. I'm not a greedy person. I do what I do. I help other people learn things that they need to, just like you taught me. And I don't need the whole 140 million.
well,
I just need a little bit.
you're not going to get 140
You know what I'm
million judgment. You get $1 million judgment here. Even if you could get it, might be in the thousands. But do you know the name of the risk management?
Yeah, I have a copy. I have a copy of their bond,
You have a
a
copy
risk management bond,
of a risk management bond.
certified copy. Yes. I also have one in Avondale too. They owe me $8 million for that situation you helped me with.
All right. Okay.
We need to talk, Mark.
Well, it sounds like, all right, first, for you and everybody else, if you're doing something like this and you want to be taken serious and you have the evidence to show that there is a valid claim that you've been damaged, you don't put things in the millions unless you've suffered severe physical trauma. And you got to make it so that we're taken serious. So usually a red flag when you are is for the sovereign citizen freeman on land type of nuttiness is when you have these enormous. Well, if you're going to talk to me, I charge $180,000 a minute. I'm like, come on, nobody. Nobody does it. So you have to make it.
Honestly, Mark. Honestly, I agree with you there. But the reason that my fees are so high is because once they touch me once, they don't want to touch me again. I have a claim in Maricopa County with the sheriff's department as well. Mark, I have about 3 or 4.
Yeah,
and they are valid and they are contractual.
No,
and they don't like.
I got to disagree with you there.
I don't want the whole thing. No, that's not my thing. I just want them to stop touching me.
But the thing is, they don't. You can make it 17 billion. That's not going to stop them. They have to see that there's teeth to it, and they're probably. It doesn't look like
they see the teeth and they leave me alone. Like right now, if I get in my car and I drive to say Tucson. Right? So I'm coming to see you. If I drive down there, they're not going to stop me. I haven't had a registration on my car in almost a year. I haven't had insurance for 2 years because it's covered by a private surety bond, which is legitimate. So there's a lot of things that but there's a lot that I've learned too, and they touch with things. I've gone into court, Mark, and I've used your script, and now I can't find the court cases on the record. When you called the prosecutor on my behalf, that court case doesn't show up anymore. My record is starting to be cleared. They're starting to pull my name out of stuff. But I couldn't achieve that without you, without your scripts, without your help.
Well, I'm glad to help. I just think this putting price tags of millions of dollars is just, it usually doesn't end well. So what I would do is I would get in touch with risk management and find out what's going on with that claim. Because after 2 years, you'd probably have to go file into court to try to, to get damages from them.
Right. Would you like to help me with that situation? I'll give you what you're worth. I know you're worth much.
It's 140 million a day.
No, they only held the car for the 30-day impound.
No, my fees are 140. As a
matter of fact, when you were helping me with Avondale, they had my car at that time that you called him. After that, the chief of police gave me my car back with no fees or fines or penalties or anything. He gave me my car back. They took it a second time, and the second time they took it, with the claim that I put on them, they crushed the car. They tried to destroy the evidence.
Jeez.
But
I'm saying
you've helped me with so much stuff, Mark. You have no idea.
Well, I'm glad to be able to help, but my fees are $2 million a day too.
Okay, well, we'll work something out. Something out.
Well,
they have to pay attorney's fees, right?
Well, let's do this. You can contact me off there, and we'll take it one step at a time. Call down, find out from risk management where the claim sits, all right? And then let me know.
Mm-hmm. All right, Mark, sure will.
All right, we'll take and yeah, give me a call Wednesday or next Saturday. Let me know if, what you hear.
Is it the same number from before?
It's the same number.
Okay. All right, I gotcha.
All right, I appreciate the call. Oh, what? Sorry about that. That was Tech Lady in Avondale. I hit the wrong button. Not really a tech issue, just a schmuck issue. Not me, not Tech Lady. We've got home bumming it. Ooh. Home bumming it.
Hey.
California.
Oh, that's a curse word now.
Hey, I'm not going out there every week anymore. So,
lucky you.
Well, I it's not. I don't like the circumstances. Why? But I don't do that anymore. I never. I don't like California. Yeah, hey, I'm wearing a Vans shirt, but hey, a free shirt's a free shirt.
Oh man.
So what do you got going on today?
Where do I start? You want to start in the my next court hearing for a moving violation is on the 30th. I don't know if that's going to go or not, or where that's going to go. I've sent in my demur, my Brady request. I haven't heard anything from him.
You're probably not if
if
it's coming up on in 4 weeks.
Huh?
You're probably not going to hear anything until this is just for minor traffic, right?
Yeah.
Yeah, probably.
And my first hearing's on the 30th. I've already set it off for the last 3 months. So.
Well, is this an initial appearance or is this a hearing on the merits of the complaint?
It's initial appearance, I believe.
Oh, okay. So
I believe. I mean, they don't have, and it's the last day on their calendar too for the year. So I don't think they're going to want to continue it, any farther. When I went to LA on my last, ticket for sitting down on the sidewalk, the prosecutor wanted to dismiss it for lack of, criminal history. So, I really didn't have to do anything other than listen to the public pretender assume guilt. So,
well, when you said the 30th, you meant of December, not January?
Yeah, 30th of December.
Oh, well, if it's an initial appearance, you can argue the demur right there. That's the first thing when I say, "Are you ready to proceed?" I said, "No, there's a demur pending." Has the prosecution presented sufficient facts to overcome the demur?
Right. And I don't think. Well, and the thing is that they don't provide any kind of a trial for moving violations. It's just a hearing or something like that.
Well, it's going to be a lot more informal than, let's say, a murder trial, but they're still going to have the cop testify. And, eventually, maybe not on the 30th. Since... Hello? Yeah, I'm here.
Hopefully.
Yeah, so...
Yeah, hopefully they will.
Well,
I've never been able to get, or I never have had a cop get on the stand in front of me. So
you've had traffic trials and they didn't put the cop on the stand?
Well, that's just it. They don't give trials for, it's not even a misdemeanor. It's a infraction.
Okay. They
don't even give trials for infractions.
Well, I've had people have trials for infractions. They still put the cop on the stand. You don't get pretrial discovery like you would in a misdemeanor, but they still put the cop on the stand.
Well, we'll see what happens on that. As far as so My sister died in December of 2017. And probate finished, I want to say earlier this year on her estate. And then my mother died May 5th of this year. And probate is now continuing due to, well, my brother doesn't really talk to me.
Well, why don't we reserve this for something off air?
Okay. All right. I don't mind doing that.
Yeah, let's keep that let's keep that off air. All right, we'll talk about that, Monday.
All right. Well, in between the 6th of January and the 6th of February, I'm just going to be busy. As far as a lawsuit for Stater Brothers goes, I guess the attorney went ahead and keeps changing the dates of the hearings on me, and didn't send me notice for the last one until after it happened. Or I should say I didn't get the notice until after it happened. He sent it like 4 days before the hearing. And then, I get it, and it's like, I think it was noon on the 13th that I got it, and the hearing was at 8:30 a.m. that day. So I didn't get any notice on that. But they're saying that I stated legal conclusions on my suit, and that I didn't state any facts.
Is that true?
I'm not sure. Huh?
Did you just have conclusory statements, or did you have facts to that those conclusory statements were based on?
Well, I had facts that those conclusory statements were based on.
Okay.
The fact that the managers of the store said that they were, and this was on the police video, that they were discussing it as I was in the store, what they were going to do, making plans. The fact that one of the managers closed one of the two exits just to funnel me to this guy that was pretending to be a security guard. He didn't have a guard card or anything. He just was wearing a uniform. The fact that the guy hit me in the head and knocked my glasses off, breaking the frames. He was demanding to see what was in my pockets for no reason. And that he put his hand in my chest before, he put his hand in my chest, and I had to push him off me, basically.
Okay, so you did.
In order to.
But you don't have to recite all the facts, so we can discuss this. So you do have supporting facts, and he's just saying, like the IRS has done before, that there are no supporting facts, just conclusory statements, right?
Yeah, well, now I'm looking at it, and he's actually stating that I'm suing the wrong people. So,
does he give an indication on who the right people would be to sue?
No.
So he's just saying that Stater Brothers, regardless of he's not saying that there are facts. He's saying Stater Brothers, even because he's lying, saying that there's no supporting facts, has no liability here. Well, I would just file a motion or a response saying and laying out just not all of them, but just citing where in the quoting certain parts of the facts, supporting facts, and which page they're on. And I would look for sanctions against the guy for trying to mislead the court. Rule 3.3.
this is what was interesting, was that he was looking to go ahead and have them sanction me $1,500 for
The F word?
for suing them. I was like, what? I couldn't believe that.
Well, that's kind of standard. The attorneys are always going to do that and try to get their legal fees. And so here you've got, I would go and to say, like I said, cite them, quote and cite the supporting facts and move for sanctions for violating the ethic rules, candor towards the tribunal. They're trying to mislead the court.
Let me ask you something. They went ahead and he keeps moving the court date. Okay. And I'm just, because he's putting the court date at the end of my, my graduation day of going to truck driving school. And I'd like to go ahead and move it to the next day from the 6th to the 7th. So my next court appearance or the next hearing is supposed to be on the 6th or February 6th. And I want to move it to February 7th. Do I just go ahead and go into the clerk's office and write something out?
You could call the attorney and ask them if they're okay with it. And if not, then you'll have to file a motion to continue.
So I can't file. So I have to write another motion to continue.
Well, ask them. First, call them on Monday and ask them if they're willing to, if they're agreeable to switching it to the next day because you have prior engagements you just can't. If they're not able, if they're not willing, then yeah, you have to file a motion to continue it.
Well, I don't like talking to them on the phone because they're going ahead and they're lying in their paperwork saying that we talked about things on the phone that we didn't.
I don't like talking to a lot of them either, but it's an unfortunate part of trying to resolve the problem. I mean, look what I did for 40 straight minutes last week. I mean, or the week before. I mean, if I'm able to do that, you know what I mean?
Yeah.
40 minutes.
I'm one of those people, by the way, I mean, Riverside's a town of 2 million people, and I'm one of those people that they remember my name. They really don't like me.
I've had IRS agents that had heard of me that I never worked with before. You don't want, that's you really got to get under their skin for you to remember their name. But
they just hate it when some homeless bum is able to do that. Able to argue with them because I'm just supposed to be some POS that doesn't know anything or doesn't, has no clue.
I'm in the same boat. People, a lot of, not a lot, but there's a handful of people, maybe a lot of these bureaucrats say, I'm just some schmuck from Long Island. And they don't like that they make admissions that they, it's like they get mad at us. They get mad at me that I'm the bad guy, that they admitted that their foundational claim was an assumption. They get mad at me. Like, what?
Yeah.
And then all the expletives, if we, but that's but you're gonna have to look if you want any chance, I think, of getting a continuance. You would need to be able to show. Look, I tried. They're not agreeable, so I have to go to the court as a last resort. And I'd put, hey, this guy's got a history of not giving you notice. I'd be looking for sanctions against this jackass. That's some underhanded lawyer crap. Yeah, but Mark, if you, home bumming it, if, it's not that he's not, it's not like he's doing anything dishonest by not giving you notice. You'd understand that if you went to law school. If you weren't just some half idiot, Mark, that if you had actually gone through law school, you'd understand that that's a common legal tactic, and no. He should be sanctioned for that.
I talked to the. I'm sorry, I didn't mean to interrupt, but
I'm done.
I talked to the. I talked to the clerk, and I told her. I'm like, wait, this thing says that there was a November hearing, and I'm all like, wait, I never had anything that said November hearing, and she's all like, well, that's not unusual.
Well, look, let's give a call on Monday and see if they're agreeable. And if not, then let me know and I can help you out with a continuance. But you got to give them. You're going to have to call and talk to them.
Yeah, well, they went ahead and they wanted something about the what was it? God, I hate paperwork. They wanted something about a statement of what I needed or what was the requirements for my evidence. And it was a form. And I suck at filling out forms. So I went ahead and I saw a part where it said, you can attach something to this form in order to, as a letter. So I wrote the letter out. I explained to them that I really suck at paperwork and I have anxiety issues about it, because I do. And I cited are you there?
Yeah, I'm here. Someone's trying to call on Skype directly instead of just waiting to instant message after instant messaging me. So, Joe, do not call the show directly when I'm on with somebody. You have to instant message me first, and then when I'm done with the call, then we'll bring you up on the show. So anyway, finish up home bumming.
Okay, so I went ahead and I basically wrote a letter citing the two videos I put online, the store video and the police body cam footage.
Okay.
And I tried to go ahead and explain that there was, there's a lot more evidence I'm going to need, like interviewing the store employees, interviewing the security guard, but nobody, even the DA, said that she couldn't find the guy. All the footage from the store from the time that I went in to the time about 5 minutes after I left. And now this lawyer saying that we spoke telephonically over the phone about this stuff, and and it's all bullshit because I only talked to him once on the phone, and I asked him, "What are you saying? What do you mean that I don't have any facts in my paperwork?" And he says, "I'm like, what do you guys want? What do you want me to change on my paperwork?" And he says, "I don't know. It's not my paperwork."
All right. Well, I'm going to try to squeeze another call in here, but just give a call on Monday and ask if they're agreeable to push it to the 7th, and if not, then Skype me and I'll help you with the continuance.
Thank you.
And yeah, don't sweat. Look, the longer it shouldn't be more than a 5-minute phone call. So don't sweat. None of at least I don't know too many people who like calling law firms. So you just got to grin and bear it. All right. So let me know what they say.
All right.
Appreciate the call. We'll talk to you off air.
Thank you.
Thanks. I'm going to drop off the regular caller line because we are near the end of the show, but I'm going to first mute up, see if we can get Joe on the phone. Hopefully he's got a good mic. See if we can do it on Skype or if I have to call the phone. Let's see. Hey, do we got Joe?
Skype or mute my speaker. Hi, thanks for having me on.
Hey, Joe, what can I do for you today?
Well, I've been mentioning this a long time to you over the last couple of years, I guess, where I'm developing this system of creating forgiveness contracts where you offer the police a contract where you show them the damage of what they're doing to you and the price. And what made me want to call is that the woman who called in a few callers ago, and she was saying she had a price for her car being taken away from her. And with this system, what I'm building up with this whole remedy coin concept is you create a financial instrument that bears the value of that huge value, right? But you don't need to get 100% of that. You get people to buy little pieces of it. Maybe not even 1% actually gets transacted, but because it's attached to a cryptocurrency that has a full market cap price, and people are buying small pieces of it, they're establishing that these small pieces are worth what the person said they were worth. So I don't know if I'm really going too far past on this.
So wait. Let me see if I understand. A forgiveness contract. So
Yeah.
you're giving a document to a police officer that's got basically a schedule of damages, and you're then selling some kind of like share in that to other people through cryptocurrency.
Yeah.
Yeah.
So essentially, instead of passing around notes that represent debt, we start passing around money that represents forgiveness of something, something that was, in my case, the Bakersfield cops stomped on my head, and they did all kinds of stuff to me. And so it's been it's coming up on 10 years, and I'll be, sending them a schedule of all the things they did wrong to me. So my heart can feel like I'm vindicated, and have prices alongside it. And the prices are there to show the extreme damage that forcing someone to do these types of things, it's a price is just it's Milton Friedman said price is information. So it's bearing that kind of information that this is an inhumane thing that's going on. And I've talked with other people who've run processes against process letters where they send a first notice, a second notice of default, opportunity to cure. These types of things are done in the collection industry a lot, and I started noticing it in a foreclosure, and started paying more attention to the notices they were sending me. And they're looking to get defaults on you. Like they say, if you deny the debt, you must deny it by this date. Otherwise it becomes a fact in the case that you don't deny the debt. And that's so what I'm trying to do with this, Mark, is to take the questions that you do, and I think they're very good, about asking for clarification. Are you assuming that just because I'm in, the boundaries of your state, that your laws and constitution apply to me? Well, I want to ask that question outside of their case in another related case where they're going to default, and we'll be able to have everyone in the world will be able to see that they defaulted on the terms of the notice, and therefore we've established fact that they don't have jurisdiction.
Yeah, but the idea here of a cryptocurrency based off of some kind of schedule of damages you're giving to a cop, I am not.
Well, no, I'm not giving it to the cop directly. This is, like you say, when you're dealing with cops, think of them as, as 5-year-olds with behavioral problems. I'm paraphrasing, and so you kind of just got to get through that time. But later on, when you can do paperwork and you can send this stuff through the mail, and this is what Remedy Coin, what my project attempts to do, is to be able to help people construct these notices and serve them, and to show defaults.
Yeah, but you can't do anything with the default. It's just like this whole, I I didn't want to spend much time on this, but it's just like people with their notaries and whatnot, and they say, well, if you don't admit or deny this within 30 days, then you default, and you don't do anything with it.
Well, they can go to an investment banker, and deposit the thing. But
deposit.
I don't know that for sure. It's a very big gray area, but I do know they can do what they can do with it is what I'm doing with it. And you can be your own bank. You can deposit the damn thing or attach it onto, like I do these things. I call them remedy. And then the one where the cops will do this, that was from Bakersfield. So I'll call it remedy.baker. And it'll probably have, trillions of dollars worth of value.
Trillions. All right. That you see when you guys start talking about these astronomical numbers, it's just like going off the rails and it's already something that I just don't see has merit, at least the way you're describing it. There's a lot of reasons.
I may not get $1,000 from it.
How much?
I may not even get $1,000 from people buying my coin, but at least they'll have something that is a part of a part of what?
You want
to call it judgment.
It's not part of a judgment. I mean,
it is a judgment.
No, you're just because
it's
you
a
have facts.
Judgment.
I'm gonna have to. This is something I don't. Yeah, I just don't see the merit.
Yeah, I don't get it, but
I don't get it. So maybe
I'm just telling you it's out there, and
yeah,
maybe it'll help somebody. If nothing else, it'll help from the standpoint of moving the challenge of jurisdiction out into instead of just a defensive case, put it in an offensive case where you're suing them you're providing the remedy yourself by forgiving them.
Well, I think you would do better at trying to expose them for what they are by confronting them at a city council meeting and asking them, especially if it's one like in Tempe, Arizona, where they do respond and they don't have a policy like Scottsdale to just sit there like statues, and confront them that way so that you can at least have video that people, you can use. It's something that's educational and it's directly from the horse's mouth. I mean, Colby Granville, we have jurisdiction because we say so. I love that. That was that is worth a.
But that doesn't get me any money. That doesn't get me any money.
But the thing is, it can be. Look, if you're going to try to get an action against them for damages, it's certainly something that can be brought up. I mean, it's part of a larger set of facts. But
to get money from them is to steal from the taxpayers.
Well, that's a much better discussion, I think an ethical discussion than it has a lot more merit in being discussed and debated than the other stuff. So I appreciate the call, but I'm going to have to end the show.
Thank you, Mark.
Hey, keep listening. Call again.
Will.
I appreciate it. It's Joe. I get the frustration. You want something to be done. But it harkens back to me the time when, let me take these stupid things off, where you had the sovereign types, or the sovereign citizens as they're known by the FBI, and the freemen on the land, the patriot type of stuff, and it's this idea that you're going to file a lien. And yeah, a lien can be actually damaging, which is why they call people like that paper terrorists. What in the hell is going on here? Let's get rid of them. Damn. It's like someone's got to get removed. Okay. Hopefully that's that. But it was, something like my time is worth $8 million an hour. I mean, something that, you could never show that any kind of economic, history that you have ever successfully charged somebody $8,000 a minute or something like that. I mean, you got my gosh, use some logic here. $2 million a day. even if you have a legitimate claim for damages, $2 million a day, yeah, that's just not going to work out. So people in the 90s and in early 2000s were filing $5 billion liens against judges. And that does have an effect. It doesn't mean that you have a legitimate claim against them, but you can gum the works up for them and you can actually cause them some harm. Not something that I would recommend doing. I think that's kind of silly. I think it's kind of reckless. But yeah, it's one thing to have a claim for damages against their insurance. And that's why I say, depending on the circumstances, $500. Let's say a traffic, you went against someone like Dick Noble or Burke up in New Hampshire, and you've got clear evidence of damage and wrongdoing by them. You file a claim. So let's say they got a $400 fine from you and they spent all that time. Oh, you don't make a $5 million claim against the insurance. You make a $1,000 claim against it. So that it's reasonable. It's rational. Look, I had to pay, or like a property tax. You want the damage done because they took X amount of dollars in property tax, and then you want your time paid for, the time it took to fight this crap. But to have them take $1,000 from you, and you want $140 million in damages. I mean, no. We're already going to be behind the 8 ball. Why make it worse by having a completely outlandish divorce from reality claim for damages? 140 million here to 60 trillions. Joe was mentioning trillions. No. Plus, anyway, if you have a claim for damages against the insurance and they turn it down, it's for $1,000. You can bring it into small claims. They can't even bring, lawyers not in most of the time. Lawyers aren't even, aren't permitted to participate. And I got to tell you, from my perspective, keeping the lawyers out, that's usually a bonus. At least it's not at the very least, you're probably not going to have 700 delay tactics, which is what, of course, Home Bumming going through, and anyone's going to go through if they file, against someone like State Bros there in California. So, yeah. I think we covered a lot of ground here today. It really is. You want to see more logic, more skepticism, and fleshing things out, testing a hypothesis, looking for the proof, seeing if the evidence stacks up. It would be great to have a one-size-fits-all remedy against them, but they're not stupid. They're very shrewd. They've got lots of people on the payroll as advisors and whatnot. They've been at it a long time, and the system isn't designed for you and I to get remedy against them. And if we can, it's not going to be very easy. It's going to be really, really costly. So even if you have solid, hardcore evidence, you've got to get past the initial motion to dismiss. And even if it's their motion to dismiss is denied, they will appeal it. And that could take years. So keep in mind, lawyers do this on purpose because they're racking up billable hours. Look at any business litigation, and they'll typically, you look at the Supreme Court, take a look at when it was actually first filed in the Court of Appeals and see how that's going to be a couple of years. Then look to see when it was filed in the trial court and then compare. It could be an 8 to 12 year difference between the day it was filed in the trial court and when it was heard and a decision made at the Supreme Court. And that could just be on the initial motion to dismiss. 10 years. And it's just going to go back to the trial court. They're going to file another motion to dismiss. They're going to file something else. And if you do get into discovery, wow. Now they can really charge you a lot of money. Now they can really make your life miserable. So it's one of them yin and yang things. There's a lot of really good things about the system and rules, but boy, they can take advantage of those and make your life a living hell, especially if you've got a class action. My gosh, the amount of money it takes to defend against or to prosecute a class action lawsuit. And if you've got and it's just like what a boat is an acronym for bust out another 1,000. Boy, when you go to discovery, it's exactly everything is going to cost you at least $1,000, and every witness. So if you look, well, I got so many witnesses, they're going to have witnesses too. And so with every witness, when you're in discovery, that could be the most expensive part about litigation, just in transcripts. So every lawyer involved has got to get a copy of the transcript, and you've got to make that. And if you've got depositions on, let's say, 100 witnesses, that's 100 transcripts. Get the idea how expensive these lawyers can make this? Because they're charging you by the minute. They're charging you for paper clips. So you can say, well, I'm not even getting a lawyer. I'm going to do it myself. But they're going to want their fees. They are going to want their fees. And if you have, you got one of these. Just keep that in mind. It's not designed for you and I to get remedy against them. It's there to enrich the lawyers. So hopefully, if anyone's on the fence or considering these types of remedies, that you'll think more about it and be more rational about it. And sometimes it's best just to walk away. If you get one of these cops who knows where you live and you want to go after a cop, I would say the only way I would do anything against a police officer is if I didn't live in Arizona anymore. So if I was going to, for damages against an Arizona cop, I would only do it if I lived outside of Arizona. Yeah. I've been stalked for stupid stuff, so I don't want that ever happening again. Anyway, I think we're going to call it quits here on the big show, and appreciate everyone's support. If you want to help support the show, it's I did it. Oh, I had to get that one last screw up before the end of the year. I won't do that. I probably will, but it's markstevens.net. And markstevens.sales.com. And if you're being attacked by a bureaucrat, you want to learn how to more effectively defend yourself, markstevens.net. We got all the videos, all the archives. We got articles. Got proof of replicated success. And you can also get the templates there. And I will be live on that there Wednesday show. So if we missed anybody today, we'll hit us up on Wednesday. So until then, salud.